Appreciate it, Robin. And thanks so much for inviting me on. I really appreciate the opportunity to return the favor. You've been so pleasant in terms of being able to talk to my clients, and now I really appreciate the opportunity to talk back to with yours. Everybody that's on the call, I've got a couple of people that are on my team here as well. So you'll see Katie and Billy also on the call. Billy is an associate attorney, and Katie is our outreach coordinator. So if you're seeing younger people going, these can't be Robin's clients, true, they're actually part of my team. I've been a practicing attorney for the last 20 plus years and focus exclusively in estate planning. I do talks like this on a fairly regular basis, and I am known for speaking very, very quickly, which is a fault of mine. But if there's anything that I talk about today that you'd like more details on, or if I need to slow down, start over, and cover something else, don't hesitate to put it into the chat. One of the members of the team will let me know because I'll probably be too in the process, in the role of it, going through, and that way I will know what questions I need to come back. And I'm an open book. So if you've got any questions, just don't do the what do I need to do. I can't give you specific advice, but general education stuff is definitely on the table. I'm going to go ahead and switch over to a shared screen. So you should be able to see a title slide that says estate planning webinar, and you will see both Katie on the screen as well as Billy in one of the shots, plus another member of our team, Jolie. This is a disclosure slide that I have to put on there. And I guess in a perfect world, I would read every word of it to you. But let's not do that because we've only got 20 or 30 minutes in here. Just know that I'm not giving you any specific advice. You can't get that unless you become a client, but I'm happy to educate you along the way. As I mentioned to you, I've been doing this for the last 20 plus years. I've got two day jobs. One of them is to help people plan for retirement. That's under the umbrella on the right-hand side that says Palante Wealth Advisors. And then I'm an estate planning firm, and they work together. I've spoken to over 10,000 people over these 20 years, and in the course of that, I've learned that what typically passes for good planning is going really deep inside of the planning as opposed to shallow. Now, I want to talk a little bit about what that means, and I'm going to pull up the screens here so that you can kind of see me draw along the way. But if we were to take a look at the way that planning is often done in the estate planning and even the financial planning world, at the very shallowest level off of it, people are focusing on products or on documents. And so what that means is that someone might have a list of things that they're looking for, like they want to make sure they have a will or they have an advanced healthcare directive. But these products or documents are only one layer to making sure that your planning is going to work when you need it. As we get a little bit deeper into our planning, we find out that really what we're looking for is to achieve a particular result. And that result is usually lined up as something that helps you accomplish whatever it is that you want. So you might want, for example, an efficient transfer after you pass away. You might want the results of limiting how much people fight after you're gone, or making sure that you have a reduced amount of costs along the way so that you don't spend as much money doing that. And so for us to be able to accomplish that deeper planning, we have to come at it from a planning standpoint. In other words, we need to see things holistically along the way. Now, only a few of these will be relevant for our conversation today, but we work on a three-pillar model. So we work on creating income confidence for folks. We work on creating a smart investment strategy. And this is all kind of colored with making sure that we are tax efficient or creating tax efficiency. Now, those three pillars are the baseline of our retirement planning, but they sit kind of long on legs on top of our estate planning, because the estate planning is the thing that can absolutely destroy any normal planning that you might want to have. For example, if you created a great budget in retirement, but all of a sudden somebody needs to go to an assisted living facility or a nursing home, Well, it's going to throw that budget way out of whack. So we want to make sure that our estate planning is in line. By the way, it'd be the same things if we were just thinking about tax efficiency. If we wanted to make sure that if we were going to leave something like an IRA to the next generation, we want to make sure that we're going to leave that in a way that is a blessing for them when they're gone, as opposed to becoming some form of a burden. So, as I mentioned, we're going to focus on the estate planning portion of it. And in order to do that, I wanted to give you a list of the kinds of documents or plan uh, pieces that go into creating an estate plan. So you have your healthcare powers of attorney, financial powers of attorney, things called living wills, which is kind of how you make sure that you can transfer as make decisions that you need when you're incapacitated, wills, trusts, and then avoiding things like probate or estate administration. And the very biggest part of my career, for it's actually the last 10 years or so, has been focused on long-term care asset protection. And that's really making sure that you don't run out of money before you run out of breath, and trying to make sure that things are lined up in case you have a long-term care event. Because the way that that tends to work is the percentages or look like somewhere between 1 out of every 4 men are going to need long-term care, so 25% of men, and about 1 out of every 2, or 50% of women, are going to need long-term care sometime in their life. Does that mean that women are more prone to needing long-term care? No, 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 no. Gentlemen, it means that you have died and she was taking care of you. So what ended up happening is that you got cared for by her, but then you died first, and now there's nobody left to take care of her, which is sort of why we end up seeing so much higher long-term care use for women. But looking at all of this falls under the umbrella of what is really good estate planning. Now, for the purposes of this webinar, I am going to focus on the getting your ducks in a row part of estate planning, and not so much on the asset protection side. That could probably be its own 30-minute webinar, if not an hour and a half discussion on how to do that planning. As we think about how to create really great estate planning, I like to focus on 3 areas or 3 kinds of results or planning approaches that tend to be favored or focused. The first one, to really create a great comprehensive estate plan, is we want to make sure that our plans are holistic in nature, meaning that they work when we need them to work. The second element of that is we want to make sure that we have safeguarded our inheritance for the next generation. One of the best things that we can do is not leave a bag of cash that might be subject to divorce or creditors later, but instead leave them in a protected format. And then the third area of really great estate planning is controlling all of the costs of estate planning, and there are 4 of them, and I'm going to go through that in the course of the discussion today. Okay, let's start with the first one, which is creating holistic estate planning. Now, holistic estate planning is really making sure that all of the documents work when we need it, and it's really trying to address what people think about in estate planning, which is that it's simply just filling out a form. If you go online, if you use AI, there are no shortage of resources to give you a document or a form that looks like it completes or does the job. But if we look at a little bit deeper, what we're trying to really accomplish, what we find is that these documents can, not always, but can fall short. So how does that show up? Well, you may know that you need to have a power of attorney as part of your suite of documents. And just to make sure we're all at the same starting line, a power of attorney is essentially a document that is used in case you become incapacitated, meaning you can't make decisions on your own, that appoints and allows somebody else to be able to make those decisions for you. Now, these financial powers of attorney, as I mentioned to you, are readily available on the internet, and they often look like a 3 to 7 page document that ends up just being something that's of a form filler. What is the goal of that power of attorney? Well, the goal of the power of attorney is to avoid something called a guardianship. Now, a guardianship is basically just the legal process that you have to go through if you don't have a power of attorney that is valid and used. Now, I'll tell you a quick war story because lawyers are fond of telling their war stories. But one of mine was that I was appointed to represent a 53-year-old gentleman that had suffered a massive stroke visiting his father down in Texas. Now, it took him almost 3 months to stabilize. But when I met him, I was appointed to represent him because his wife was trying to begin a guardianship over him. The reason why they needed a guardianship, by the way, is that even though she was named as the beneficiary of his IRA and the beneficiary of his investment account, none of that mattered because he wasn't dead yet. Because he was simply just incapacitated, it meant that you were able to you weren't able to use that beneficiary designation until somebody had passed away. Okay. So we want to talk about using a power of attorney that works when we need it. And when we were going through that guardianship, what had happened was these two, husband and wife, they actually had a power of attorney that was drawn up by a lawyer about a year and a half before he suffered this stroke. And when she went to go to use that document with Merrill Lynch, who had the investment account, they kind of held it up to the light. And they said, this gentleman can do certain things in their account, but the power of attorney doesn't give him the authority to do that. And so it means that can't accept or allow this to happen. So what I'm going to do is I'm going to just focus in on the powers of attorney. But what I want you to appreciate in this conversation is that I could go this deep into each of the major planning documents. If we wanted to, I could go this deep into a will or a trust or a healthcare directive. But for sake of brevity, the fact that it's only about 20 or 30 minutes that we're going to be spending here today, I'm just going to focus on a power of attorney. Now, one of the things that determines whether or not a power of attorney is effective when you need it. Oh, by the way, before I go into what's on the slide, what ended up happening with this family, because they had to go to the guardianship, is they ended up spending about $12,000 on the guardianship. Meaning, the lawyer that was appointed to represent the wife, he charged about $7,500 flat fee. We needed to get two medical affidavits from doctors swearing that this person could never recover from their incapacity. That was $1,000 each. And then I was compensated because they had money at an hourly rate of about $200 an hour, which is like less than half of my normal hourly rate. But it was something that the court gave me as part of the appointment. The point is that $12,000 later, she was finally empowered to deal with her husband's estate, even though he's incapacitated, but deal with his affairs. And it could have been avoided if she had a power of attorney, if they had powers of attorney that were working when they needed to them. So here are the four things that make that happen. The first is to make sure that you have a document that is timely in nature, meaning it is recently signed. There is no statute that says that if you have a power of attorney of a certain age, then a financial institution has to accept it. In fact, there's a wide range of these across the spectrum, from 10 years being good to as little as 90 days. And you never know whether or not it's going to be accepted until and or unless you bring it to the financial institution. By the way, if you'd like to know who the 90-day person or institution is, it's Bank of America. So if you've got money at Bank of America, they presumptively reject any power of attorney that is older than 90 days. And they don't do it because they love you or because they care about you. They do it because they're afraid of getting sued for releasing money. And so they just draw a line and they call it 90 days. Some people are a year, some people are 2 years. By the way, I'm going to give you some free legal advice. You never thought you were going to get this on a webinar, but I'm giving it to you, free legal advice. If you have a power of attorney that you have signed at any point in time, go and bring it to your financial institution and ask them to play make believe. Make believe that I'm incapacitated and tell me whether or not you would honor this or not. Because the time to figure out whether or not you've got a good document is while you still have the ability to sign a new one. Okay. Timely document is the first one. The second one is making sure that you have a lot of provisions in there, what I'm calling a broad power of attorney. Because these documents, and I'm going to use a legal phrase here, but it's a document of strict construction. And in the legal world, what that means is if you don't list the thing that you can do in there, then it doesn't have to be a valid document. So, by contrast, our powers of attorney are nearly 30 pages long. Do I use 30 pages to be impressive? Maybe, but not really. The reason why I use 30 pages is because the paper is cheap. But getting you to come and sign a new document after you become incapacitated is impossible. And so it would be better if we threw everything in there plus the kitchen sink. And one of the ways that you can determine whether or not you've got a power of attorney that is more likely to be accepted is see how long it is. If it's one of the 3-page jobbers that are in there, 6 or 7 page documents, you're going to be at risk to a financial institution not accepting it. And by the way, that free legal advice about getting it trial, kind of doing a free test with them, should be done at every financial institution where you have money because they can do either one along. I mean, each of them can have their own results from that. Two other quick ones, and then I see a question in the chat that I'm going to address. You want to make sure that you name backup. So if you're married, of course you want to name your spouse, but you want to name somebody that's going to be a backup to the spouse. And again, if you're feeling comfortable, we can name 2 or 3 people that are in order. Again, the paper is very, very inexpensive. To add those names is very, very inexpensive, but to have a failure where somebody isn't named as a backup, very, very expensive to have to go through the guardianship afterwards. The next one of that, by the way, is sharing those documents. So these documents are worthless unless people have access to them. It's one of the reasons, by the way, why we plaster our name over every document that we create in the little footer so people can find us and we can give them the document when they need it. But I recommend, and when you do a plan through us, we create a folder with all of your estate planning documents electronically so you can download them and you can share them. But I recommend that you put at least the healthcare directive and what they call a HIPAA release, which you should be familiar with if you're a client of Robbins, but it's a way of being able to access private medical information. Those 2 documents should be in the people's hands that we've appointed to make those decisions, because that's the one that they've got to rush to the hospital for. Now, I see a question in the chat, and I want to address it, which is the difference between a springing power of attorney and it says durable, but I'm going to contrast it with something called an immediately effective, because it's not quite the same thing. So when you set the dials on this kind of document, you can set it up so that it is immediately effective when you sign it. As soon as you put it in place, assign it in place, then you've got a document that works. Or you can set one up that is effective when you become incapacitated. That's the springing type. There's no right answer to this because they're 2 sides of a coin. If on the one hand you have a springing power of attorney, then you don't have somebody walking around with a blank check to your life. But when you go to present it, the financial institution can require you to prove that you are in fact incapacitated. So it's kind of like easier, you eat more protections. You feel like that somebody's not walking around, but I've got a bigger hurdle when it comes to being effective. If I have the immediately effective one, the other side, then what I get is I get something that is no problem when I go to use it. I don't have to prove that they're incapacitated, but I got to worry that somebody has this kind of blank check to my life. When you're naming a spouse, might I suggest that you are absolutely going to give them an immediate power of attorney because they already have a blank check to your life. But if you're dealing with your children, if you're dealing with the next generation, maybe you'd want to create a springing one. So those are things that we counsel on along the way. I saw in the chat the word durable, and I want to explain what that is because the durable power of attorney says that it doesn't stop if you become incapacitated. So what it means is I could give an immediate power of attorney that is non-durable. So it's immediately effective, but if I become incapacitated, it doesn't work any longer. That's non-durable. If I went one that's immediately effective and durable, then if I become incapacitated later, it's still going to work. Okay. So typically, You would get an immediate one that is durable because the whole point about having it survive any period of incapacity is you don't want to have to prove that your incapacity means anything different. Hope I addressed the question. And if I don't, you can kind of put it in there and go on. All right, great. Got a thumbs up from that. Let's go back to the slide deck because I want to talk about another area in estate planning. And I'm going to focus on the costs that are associated here. Now, we deal with clients that are located across the country. Our estate planning tends to focus on folks that are in New Jersey and in Pennsylvania. And when we think about the four costs of estate planning, let me just take this off real quick and let me go through the four costs and then I'll put it back up again. There are four costs to estate planning. Cost number one is the documents themselves. How much does it cost for it? Whatever it's going to be. If it is a will, if it is a trust, if it is a power of attorney, you have an upfront cost. That's cost number one. Cost number two is the cost of integrating your assets. So, what I mean by that is most people believe that a will covers 100% of their estate, but it doesn't. A will never cover your IRA. It won't cover an annuity. It won't cover life insurance. It won't cover any assets that you jointly own with somebody else. And it won't cover assets that are covered by a payment on death or a transfer on death. Just won't cover them. So when we think about getting an estate plan that works, we have a cost associated because I could put a will in place and then I have to go and do the work to make sure these other assets that are not covered by the will also go according to how I want. That's a cost. The third cost of that is the cost of updating your documents or the cost of inaction. So, for example, I don't know how many people are in New Jersey. I don't know how many people in Pennsylvania. I don't know how many people are in California, but welcome, everybody. In New Jersey, there was an estate tax up to the year 2018, which is that if you left more than $675,000 to the next generation, you were going to owe some estate tax on it. Now, it turns out that they have repealed it. But if you had a plan written in 2015 that was all about saving New Jersey estate taxes, this plan is now out of compliance with what we need now. So over the course of your life, things are going to change. People are going to die, they're going to be born, you're going to change financial accounts, you're going to change what you want, and the law is going to change. All of that is going to be ground moving underneath you. So there's a cost to making sure that your document is still in line with the way that you wanted stuff to go when you originally created. Now, we solve that in our office by having a client updating program where it's like you create in a plan, you've invested some money to do that, but when it comes time to update it, it's a much lower cost. So think about this like tuning a piano. If you haven't tuned a piano in years, it's going to cost a lot to get it in tune. But then it's going to cost a little bit less to keep it in tune. And that's really what we want. We want the piano to play well when we are eventually going to sit down and play our masterpiece. And that happens with the estate planning. That's our third cost. The fourth cost is the cost of estate administration. This is the cost that comes after you pass away. And it's usually the one that people think the least about when they create an estate plan. If you've ever created an estate plan, how many of you asked your estate planning attorneys, how is my estate going to be charged when I die? Do you have an estimate about how much my estate administration fees are going to be? It turns out that most people don't ask that question. It's kind of a dark, morbid question, but it's a really important one because it is helpful to trying to control all of the costs. And it's really the biggest piece of the iceberg is under the water. It's the largest of all four of those. The cost of estate administration is typically the largest cost. And don't take my word for it. Go ahead and Google or search AARP fees for estate administration. And what you'll find is that, people there will say it's anywhere between 3 to 5%. Okay, let's focus on the fourth one and how we control for it. So that fourth cost of estate administration can be controlled by selecting a document format that covers all of this stuff. For example, this is the trust versus will discussion. A lot of people ask, do I need a trust or do I need a will? I started blogging before anybody knew what blogging was, but on my website to this day, a post from 2012 that talks about the trust versus will is still the most visited piece on my entire website. It's really kind of a distraction because when most people are talking about the difference between a trust and a will, they think they're talking about cost. So they say, well, listen, a trust is more expensive or it's only for rich people. But there are three things that have no regard to whether or not you are wealthy that a trust might be more beneficial than a will. The first one is that if you're a New Jersey resident, you want to make sure that you're avoiding a tax lien when you pass away. Do you remember I talked about the estate tax that was repealed in 2018? Well, the state of New Jersey didn't do away with all of its revenue that comes after death. They kept an inheritance tax. For most people, the inheritance tax will not apply if you're going to leave things to a spouse or children or even grandchildren. But the moment that you start leaving money to anybody else, an inheritance tax comes in. Here's the thing. The state of New Jersey doesn't know who you're leaving your stuff to. So if you are a New Jersey resident when you pass away, your financial institutions are ordered to freeze your account when you pass away so that they can ensure that they get their tax money if it's due. By the way, if you've ever had this happen when one of your loved ones, when you passed away, just let me know in the chat that I'm not nuts and that other people will see that as well. But people will go in and have this estate tax lien, inheritance tax lien. Turns out you can avoid the lien. You can avoid the freezing of your assets. But the way that you do that is to have a revocable living trust. You can go search this on your own. If you go to the Division of Taxation in New Jersey and you search for the tax lien at death, it will tell you it does not apply to anything owned inside of a trust. Removing that lien can take up to 18 months. And so we say to people, hey, do you just not want to have your family wait 18 months? Can we use a trust instead? And by the way, when we're talking about that cost thing in our firm, we don't charge differently for a trust. We have one flat fee for our planning. So now, whichever is the best document. Second way that we can help reduce costs for estate administration is we can avoid multiple probates in different states. This is best identified if you have real property in more than one state. So if you have a home in New Jersey and you have a home in the Poconos, or if you have a home in Pennsylvania and you have a shore home, or you've got a place here and you have a small place in Florida. If you have property in more than one state, you will be subject to two probates where a trust would help you avoid that. And then the last one is that if you were going to need probate at all, that is typically a regulatory process that takes some time. For example, in Pennsylvania, when you go through a probate, you have to publish your will through the Register of Wills in two different periodicals, a newspaper and a bar journal of all things. I didn't even know those things even existed any longer, but apparently they're funded exclusively by people having to post notices because someone's passed away in Pennsylvania. But it has to be in the county. And that takes time. If you had a trust, we could give people immediate access to your assets along the way. So these are ways of controlling those costs so that we can streamline how quickly somebody can get access to it. There are four major documents to your estate plan. We want to make sure you have a will and a trust. By the way, you're going to get both because a will is like a bit of a safety net. It catches anything that doesn't go into the trust and it pours it in. And then we want a power of attorney and we want healthcare directives. If you start with those major four, you will cover most of what you need in estate planning. And in fact, one of the things that we've done is created for you a checklist. Absolutely free, no sales pitch involved in there. But if you would like to go through a checklist to see whether or not you have a plan that is comprehensive, takes care of what you need, then you can scan the QR code that's on the screen, okay? And we will send that to you automagically, and that's yours with our thanks for paying attention. I am at the end of what is a promised 30-minute webinar. Okay. Oh, by the way, Katie from our team has also put a link in the chat. So in case you want to click that and fill out the form because you're on a computer and you don't have your phone available, you can do that as well. I am done with my 30 minutes. As you can tell, the shortest talk that I give is somewhere between an hour and a half and 2 hours, and I flew through this one, but I will open up to any questions that anybody has. And I am at your disposal if you want to talk about anything else that's related to estate planning.
Thank you, Victor. And yeah, if anybody wants to ask a question, you can come off of mute and just go ahead and ask that.
It's your only chance to get free legal advice in this format. Don't waste it.
Yeah, gee, Victor, I should have
One
had people.
question.
Please go ahead, Susan.
Um, with the New Jersey tax lien
Yeah.
and having everything frozen until your beneficiaries are confirmed, are the accounts frozen from your executor as well? Am I understanding this correctly?
Yeah, I'll explain a little bit better because you said a couple of things that were what I said, but I wasn't thorough enough in explaining it. Okay.
Okay.
So
And
what
I'm going
ends
to
up
mute myself so my bird doesn't drive everybody crazy.
no problem. So what happens when you pass away is half of the money is frozen, 50%. The other 50% your executor can take. Okay. What's frozen is until you've proven that you either owe no inheritance tax or you've paid the inheritance tax what it is. So even just proving who your beneficiaries are doesn't release the lien. It's basically being able to establish that you either owe no tax or here I've paid the tax that I've owed, and then they release it. So your executor can access 50%. By the way, the reason why they give them 50% so they can pay the tax bill from it. That's not really for any other reason, but they want to make sure that they're going to get paid their tax bill. But 50% is available, 50% is frozen. If you have it in a trust, 100% is available. And now you can do with it whatever you want. This also comes to bear when you go and sell your property. So when you sell your property, if you haven't cleared the waivers from the tax lien, that money stays in escrow with the closing agent and none of it's distributed. And so that's another barrier because many times a home is people's either largest asset or the thing that they're using for liquidity to pay everything else. It's like they're waiting to sell the home and now here's a few $100,000 available. That stays in escrow until we clear it. So many times the act of creating a trust carries with it the immediate act of putting your home into the trust. So that way we have access to that asset. Did I answer your question about clarifying all of that? Yeah, good. I see a nod. Good. Any other question that's in there? Katie, we got an issue with the link from somebody that's in there. If you want to go check it out and see if that is working or not. And by the way, Pete, is that, by the way, the link on the chat or is that the QR code? You can help clarify that and we'll make sure that we'll get it there.
It's the QR code. When I
Okay.
when I click on it, it just keeps sending me back to refill out the information.
Well, we can check real quick to see if we actually captured it the first time or we have 5 of them from you. And then we'll make sure that we've got that there for you, okay, to see if they have it. And okay. And if not,
Yep.
we'll just capture emails if you want to put them in the chat and we'll sure you send it to you directly. It's fine. We play nice. Any other questions substantively on the presentation in any area that's related to estate planning or even elder law planning? I can even give you a brief thing to make sure that we cover asset protection too. Okay, hearing none. Thank you so much, Robin, for inviting me on. I really appreciate the opportunity to talk to your wonderful clients here and give them more information about estate planning. It has been a pleasure to join you here today.
I appreciate it, Victor. And if anybody does have questions later on for Victor and you need his contact information, you can feel free to reach out to me and I will get you right over to them so that they can answer your questions. But I appreciate it. I appreciate you guys being here, Victor. I really thank you very much for your time. Your team is awesome. Thank you guys for being partners with me here. All
Appreciate
right,
it too.
everybody. Thank you very
Thanks so much.
much. Have a great week.
Bye, everyone.